A common question or situation that we encounter is one where the original will cannot be located. In fact, often when we ask a party if they have the original will, they'll respond and say yes. But when we receive the will, what they have is actually an original copy of the will that may be 10, 15, 20 years old. But upon closer examination, we're able to tell that it's not the original will. So as far as the probate courts are concerned, when we have these situations where we only have a copy of the will and we don't have the original, the presumption is that the testator, the person who wrote the will, has revoked or destroyed their original will. And it's their intent that the will no longer remains valid. So with all that being said, and us taking that into consideration, there's steps that you have to take when filing to probate a will and present to the court a copy of the will. And normally we have to do an affidavit of diligent search where we're basically explaining and showing to the court the steps that were taken to locate the original will and any other additional information that we can add into that affidavit that would accompany the petition. One essential element is we have to track down the witnesses to the will. So the older a will is, the harder it is to locate witnesses. More recent wills, a lot of times what we see is the witnesses will have the same address, which means that somebody just went to a UPS store or some other business that offered notary services and two employees signed the will as witnesses. So in those instances, it may be a little bit easier to track down witnesses. Other times, witnesses may be neighbors or family members who are not closely related to the decedent, such as cousins or aunts or uncles. They may not be the heir, so they're not precluded from serving as witnesses to the will. So if you are considering probating a will that's a copy, you do need to do some legwork and track down the witnesses. If you can't find the witnesses to the will, then that leaves you in a situation where you will have to find two non-interested parties. And by non-interested, we mean people who are not benefiting under the will. They're not beneficiaries under the will. Two people who are familiar with the testator's signature who can do an affidavit and explain why they're familiar with the signature and why they can recognize the signature. And the court can accept that and probate the copy of the will. So if you have a copy of a will, not sure where to find the original will, it is imperative that you speak with an attorney. The attorney can discuss the situation with you and help you decide what's the best course of action as far as probating the will. In some instances, a parent leaves their entire estate to be split equally amongst their children, which is the same way the property would be disposed of if the estate was probated without the will. So sometimes it may be a little easier to just proceed as if there's no will, as opposed to trying to find and track down the will. And if there's a situation where a family member who is excluded from the will has access to the home and they've gotten a copy of the will first, you can almost guarantee that the will has been destroyed. If you are representing or plan to represent a loved one's estate, you should try to get access to the home and important documents immediately to make sure that the will is preserved in the event that there is a will.